1993 competition law training tape recorded for a conference organizer by Susan Singleton.
Audio cassette on competition law. Susan Singleton, Solicitor with Bristow's Cook and Cartmel, London. Competition law promotes effective competition to achieve more efficient allocation of resources. It is a political and economic tool which regulates markets. This may sound a little esoteric, but competition law has important practical implications for companies of any size. The European Commission has powers to fine companies up to 10% of their annual worldwide group turnover. In July 1991, Tetra Pak was fined a record £52 million. Fines of millions of pounds are not uncommon. In the UK, companies which are subject to orders of the Restrictive Practices Court, who subsequently breach those orders by entering into anti-competitive arrangements, can be fined unlimited amounts for contempt of court, and individuals aiding and abetting the contempt of their employer or others can be fined or even jailed. Ignorance of the law is no excuse in this field. This cassette gives an outline introduction to the principal areas of EC and UK competition law which affect businesses. Its purpose is to educate those involved in running businesses as to those areas where there should be awareness of competition law so that appropriate advice can be taken. An introduction to competition law is followed by a series of case studies. The case studies, which are available with the audio cassette, should be studied by those listening to the cassette. They set out a hypothetical series of facts which relate to 5 different competition law areas. These broadly follow the form of the discussion of competition law which follows the introduction. Those listening may read the relevant part of the case study, having heard the description of the law, and then consider leaving the cassette aside for a time. The implications of those hypothetical events in the case study can then be considered. After the 5 areas of competition law raised in the case study have been considered, the cassette concludes with a description of some of the measures which companies can take to minimise the risk of infringing EC competition law. UK and EC competition law affect 3 principal types of activity. 1. Restrictive practices and agreements between companies and individuals. 2. Unfair conduct by large companies. Anti-competitive practices such as cutting off supplies of goods to a customer, selective or predatory pricing, etc. And 3. Mergers. Looking first at anti-competitive restrictive agreements, under EC competition law, Article 85(1) of the Treaty of Rome prohibits all agreements which affect trade between member states and which have as their object or effect the prevention, restriction or distortion of competition within the common market, and in particular those which a. directly or indirectly fix purchase or selling prices or any other trading conditions, b. limit or control production, markets, technical development or investment, c. share markets or sources of supply, d. apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage, and e. make the conclusion of contracts subject to the acceptance by the other parties of supplementary obligations which, by their nature or according to commercial usage, have no connection with the subject matter of such contracts. This slightly convoluted Euro wording masks a fairly straightforward concept. Agreements between companies or individuals which restrict competition are prohibited. By Article 85(2), those restrictions will be void. What this means is that if an agreement is entered into, under which 2 competitors, for example, agree to the prices at which they will each sell their goods to their own customers, if one party tried to sue the other for not sticking to the agreement, then the restrictions would be unenforceable. i.e. the court would not uphold them. In addition, under EC Regulation 17, the Commission has powers to fine companies entering into agreements which infringe Article 85 up to 10% of their annual worldwide group turnover. Finally, third parties have a right to sue those who have operated such arrangements for damages, where the third-party company has suffered losses arising from such arrangement. Those types of actions are brought in the national courts but have been quite rare. A number of basic concepts under Article 85 need to be considered. First, agreements does not just mean written agreements. Oral arrangements and gentlemen's agreements, even if they are not intended to be legally binding, will be caught. And not just agreements, but arrangements and concerted practices are caught. It is a very broad definition. B, the second important issue is whether trade between member states is affected. Companies do not need to be concerned about EC competition laws, where an arrangement would not affect trade between EC member states, although UK competition law may well apply in those circumstances. Clearly, if an agreement involves exports from the UK or the dividing of territories within the EC, there will be little doubt that trade between member states will be affected. However, it is unwise to assume that just because an agreement is entered into in connection with the UK only between two UK parties, that there will be no effect on trade between member states. The European Commission, in its case law, has been quick to find an effect on trade between member states, even if the agreement simply has a potential such effect. However, the Commission has issued a notice on agreements of minor importance, which states that where the parties have less than a 5% market share and a total worldwide turnover of less than 200 million ACU, that's £153 million, then there is unlikely to be an appreciable effect on trade between member states. It is always worthwhile considering whether that notice can be used. Although it is not legally binding on the Commission, and if the Commission has defined market shares very narrowly, many companies exceed the 5% market share criterion, so that even if their turnover is low, their arrangement could have an effect on trade between member states. Another concept is that of restrictions. Having considered whether an arrangement affects trade and whether it is an agreement under the provisions of Article 85, it is necessary to look at the restrictions themselves and see if they are the sort which would fall within Article 85. Those listed and mentioned at A to E above, taken from Article 85 itself, give good examples of the types of restrictions which can be caught. Although the list is not exclusive, and the Commission often extends the bounds of Article 85 beyond the list. Typical restrictions include companies agreeing not to compete with each other, collusive tendering, agreements on price, and agreements which prevent companies buying goods more cheaply in one territory of the EC and importing them into another. Turning to notification and exemption of agreements, agreements which infringe Article 85 may be notified for an individual exemption under Article 85(3). This involves the completion of a Form AB, which is available from the Commission, and the submission of detailed information required on an annex to the form, giving market share figures, a description of the parties and the products. Putting together the information for a notification is a substantial exercise and should only be considered where it is essential that an exemption be obtained. In many cases, general exemptions have been issued by the Commission for specific categories of agreements which fall within the requirements of those regulations. There are general exemptions in a number of categories, including exclusive distribution and purchasing agreements, patent and know-how licensing arrangements, research and development and specialization agreements, franchising and motor vehicle distribution servicing, insurance, etc. However, those agreements are not automatically exempt. It is necessary that the regulations are examined as they set out those provisions which are allowed and those provisions which are not allowed in agreements of that sort. It is only if none of the blacklisted restrictions which are set out in the exemption are present that the parties will be free of the risk of infringing Article 85. Turning to UK competition law, in the UK the Restrictive Trade Practices Act 1976 requires that restrictive agreements must be registered in advance at the Office of Fair Trading. Restrictive agreements are not banned outright, as under EC law, and registration is a simple, quick and easy process involving sending the agreements with a form called RPC, obtainable from the Office of Fair Trading, to the Office of Fair Trading. If there is any doubt about whether an agreement falls within the Act, then a fail-safe registration can be made to the Office of Fair Trading to obtain their views on whether or not the agreement is registrable. The consequences of failure to register an agreement should next be considered. If a registrable agreement is not registered, then the restrictions will be void and the parties to the agreement are at risk of being brought before the Restrictive Practices Court for orders to be made against them. Once orders have been made, the company has to be particularly careful not to infringe the law again, as subsequent infringement could result in fines for contempt of court. However, for first offences, the only power is to have an order made against the company. There is no power to fine for a first offence in the UK. Once an agreement has been registered, the Office of Fair Trading will examine it to determine whether it falls within the Act. If it does, then they will consider whether it should be referred to the Restrictive Practices Court. If the restrictions are not significant, then many agreements are simply placed on the public register. However, this can be a problem for companies because the public register is open to public inspection and the parties to the agreement are published in the Office of Fair Trading's magazine, Fair Trading. There is no right to confidentiality for general business secrets. Companies should therefore consider, before they enter into agreements, amending the agreement so it does not fall within the Act, or abandoning it if registration and the subsequent publication of the arrangements is not acceptable. In determining whether an agreement falls within the Act, the following questions should be asked. 1. Are there two parties carrying on business in the supply of goods in the UK, or two parties carrying on business in the supply of services? If not, then the agreement will not fall within the Act. 2. Are there restrictions on two parties in the agreement, looking at all ancillary agreements too, including side letters and any informal understandings, even if oral, which have been entered into by the parties as part of the same deal? 3. Are those restrictions of the sort set out in Section 6, if they are goods restrictions, or Section 11, if they are services restrictions? Or is there an information agreement or a recommendation by a trade association? Section 6 and Section 11 set out the types of restrictions which are caught. These include restrictions as to the prices to be charged, quoted or paid for goods, or recommended for goods, or the prices to be recommended for the resale of goods, the terms and conditions on which goods are to be supplied, the quantity or description of goods to be produced, supplied or acquired, the processes of manufacture to be applied to goods, and the persons to or from whom goods are to be supplied or acquired. 4. Are the two parties to the agreement part of the same corporate body? If so, they are counted as only one, and the Act will only apply where there are restrictions on two parties. If an agreement contains, for example, 8 restrictions on one party and none on the other, then the Act will not apply, which is a very different approach from that taken under EC competition law. 5. Are there any exemptions under the Act which help, or restrictions which could be discounted? Under the Act, there are various exemptions for certain forms of exclusive dealing agreements, for example, and restrictions which relate only to the goods supplied are not counted. 6. Can the agreement be amended before it is entered into, so it does not fall within the Act? An agreement must be registered before it is entered into. If an agreement which should have been registered is subsequently discovered, then it should be terminated and entered into again, having been registered in time on that occasion. The next topic is that of abuse of market power, first under EC law. Under Article 86 of the Treaty of Rome, companies which enjoy a dominant position, i.e. control a large share of the EC market, must not abuse that position. Article 86 therefore covers the conduct by one company, whereas Article 85 deals with arrangements or agreements between two or more companies. Under Article 86, examples of abuse include A. Directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. B. Limiting production, markets or technical development to the prejudice of consumers. C. Applying dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. And D. Making the conclusion of contracts subject to acceptance by the other parties and supplementary obligations which by their nature or according to commercial usage have no connection with the subject of such contracts. But the first question is whether a company enjoys a dominant position in the first place. In assessing this, the most important question is that of market share. Generally, a company which has more than 40% of the EC market for a particular type of goods, or a substantial part of the EC market, which could be one large member state such as the UK, will be in a dominant position. Once a company has established whether it is dominant or not, there is no prohibition of dominance. It is simply the conduct of the company concerned which could be called into question. Dominant companies therefore need to be careful not to impose unfair prices or conditions, or require purchasers to buy other goods which they do not want, so-called tying clauses, or treat similar customers in a different manner, i.e. discriminate against them for no good reason. The Commission has the same powers as under Article 85 to fine companies which abuse their dominant position. Under UK law, the Competition Act 1980 permits investigation by the Office of Fair Trading and subsequently by the Monopolies and Mergers Commission of anti-competitive practices. However, there are only half a dozen or fewer investigations each year, so infringement of the Competition Act 1980 is not usually a major concern. Anti-competitive practices include practices which eliminate competition or prevent the emergence of new competitors or distort competition. Examples of anti-competitive practices include a very long-term supply contract with onerous termination provisions, or tie-ins as described above, or restrictive licensing policies such as refusing to license intellectual property rights, such as patents and trademarks. However, the Competition Act 1980 does not apply to firms which have an annual turnover of less than £5 million, where they also have a market share of less than 25% of the relevant market. The third and final category is that of merger law. In the EC, the merger regulation requires very large mergers with a so-called community dimension to be notified to the European Commission in advance. Failure to notify a merger brings substantial powers to the Commission to fine the companies concerned. However, the EC Merger Regulation 4064/89 only applies to very large mergers. A merger will only have a community dimension with a total worldwide turnover of the companies concerned exceeds 5,000 million ACU, which equals £316 million, and the total EC-wide turnover of at least two of the companies must exceed 250 million ACU, which is £130 million. Even if both those requirements are exceeded, the merger will not have a community dimension where each of the companies involved achieves 2/3 of its annual turnover in one member state. It can therefore be seen that very few mergers fall within these thresholds. If they do, then it is essential that the merger is notified in advance. Turning to UK merger law, this is much more likely to be of relevance to many companies. Under Section 64(1) of the Fair Trading Act 1973, a merger situation is at risk of being investigated by the Monopolies and Mergers Commission for up to 6 months after it has taken place. The merger will fall within these requirements if it passes one of two tests, the assets test or the market share test. Where the value of the assets taken over exceeds £30 million, then the merger might be referred to the Monopolies and Mergers Commission, or where, by virtue of the merger, a company acquires a market share of more than 25%, or a company which already has a market share over that figure increases its market share by virtue of the merger. Turning to notifying the Office of Fair Trading, where a merger is in prospect, then the companies concerned should consider UK merger law carefully and decide whether or not the merger is likely to fall within the law. If the merger does fall within Section 64 of the Fair Trading Act, there is no obligation to notify the Office of Fair Trading in advance, but it is sensible to do so. This can either be done formally once the merger is part of public knowledge, or the parties can apply for confidential guidance to the Office of Fair Trading. If no clearance is sought, the parties are at risk of an order of the MMC being made against them that they should divest themselves of the assets acquired. It is for this reason that clearance is sensible. Other competition laws. These are the three main areas of UK and EC competition law. However, there are three other areas in the UK which are worthy of consideration. The Resale Prices Act 1976, which is discussed below, prohibits maximum resale price maintenance, and there are provisions in the Fair Trading Act 1973 allowing the Monopolies and Mergers Commission to investigate monopoly situations in connection with a particular industry rather than the activities of one company. Finally, Section 44 of the Patents Act 1977 provides that certain clauses requiring a patent licensee or the purchaser of patented products to buy other products which it may not want, i.e. so-called tying clauses, may be void under Section 44 of the Patents Act. In addition, companies may have a complete defence to proceedings for patent infringement in the future where such ties are in existence in connection with patented products. Uses can be made of competition law. It is not just a business disadvantage for companies. If a competitor is cutting off supplies or acting unfairly in relation to a company, then that company can make a complaint to the European Commission and sue the company for breach of competition law in the courts. Even the threat of such complaint or legal action may be sufficient to ensure that the company against whom the complaint is made undertakes the action which is requested of it. There follows more detail on the areas of law covered above, relevant to each part of the case study in turn. These follow the numbers in the case study. 1. Cartels. The first scenario in the case study concerns activities which many people are aware infringe competition law. However, this does not mean that such activities are never undertaken. Many employees, often for no personal financial gain, find it easier to agree with competitors which available jobs open for tender they should go for. Important legal points to bear in mind in this area are that it does not matter whether the arrangement is binding or not, it could still infringe competition law. In practice, an oral arrangement is less likely to come to light than one which is in writing. But disenchanted or dismissed employees or other ex-employees may complain to the Office of Fair Trading in the UK or the European Commission in Brussels. Or the European Commission may be undertaking a raid or investigation of the competitor's premises, and during the course of that investigation, perhaps into another unrelated area, information can come to light. Even if documents are selectively destroyed at the premises of one company, copies of the documents may be in evidence at another company's premises. In one case in the UK, an individual in the northeast of England kept track of the prices he was quoted for kerosene for domestic consumption over a period of years, which information was sent to the Office of Fair Trading, when it appeared that price rises for the products suddenly started to move in line and be very similar as between the different companies concerned. There is no doubt that an arrangement with competitors sharing jobs or contracts which are available infringes both UK and EC competition law. In the UK, where a company is already subject to orders of the Restrictive Practices Court, then fines can be levied against the companies concerned for contempt of court, unless they have taken action to forbid their employees from entering into such arrangements, which was recently the subject of consideration in the Supply of Ready Mixed Concrete No. 2 case. It may be appropriate here to leave the audio cassette and consider the first scenario in the case study now. 2. Abuse of a dominant position. Article 86 of the Treaty of Rome prohibits abuses of a dominant position. One of the first questions to ascertain is whether a company does enjoy a dominant position, Although market shares are important, they are not the only factors which are relevant. A company which has a market share of, say, 20% could still be dominant if all its competitors have a market share of, say, 1%, although usually a market share of at least 40% is required. This is not set out in any statute. An ability to control the market is an important factor in determining whether or not there is dominance. Defining the relevant market can be particularly difficult. In some industries it will be quite clear, but consider spirits. There may be a market for spirits generally, or there could be separate markets for whisky and gin, or there may even be separate markets for different types of whisky, as perhaps the bottom end of the product market would never compete with those products at the higher priced end. In determining what is the relevant market, the Commission will look at what products would be regarded by consumers as substitutable with another product, and they will apply various economic tests. It is always better to err on the side of caution in determining what the relevant market is, and take the market which would result in the higher market share for the companies concerned. Where a company is in a dominant position, then the next issue is whether there has been an abuse, as there is no general prohibition on enjoying a dominant position. The dominance is simply in many cases an illustration of the effectiveness and efficiency of the company concerned. Imposing unfair prices is regarded as an abuse of a dominant position, although there have not been many cases concerning excessive prices. It is difficult to determine what amounts to an excessive price. Pricing low to drive out a competitor, i.e. predatory pricing, is banned. In the ECS AXO decision, the Court of First Instance held that any unfair commercial practices on the part of a dominant undertaking intended to eliminate, discipline or deter small competitors would thus fall within the scope of the prohibition of Article 86 if the conditions for its application are fulfilled. In that case, aggressive price cutting was held to infringe. Restricting markets can amount to an abuse. In the United Brands case, forbidding a distributor from reselling the product in certain circumstances, in this case reselling bananas when they were still green, was held to infringe Article 86. Another area of abuse is treating similar parties in a different way. For example, if a new competitor is setting up in business, it would be an abuse to offer them worse terms than other customers who were not setting up in competition. Equivalent transactions must be treated in the same way, and it is necessary to see whether there is an objective justification for treating one company differently from another. Requiring companies to buy goods which they may not want is a classic example of an abuse of a dominant position. A company may have products which sell well and others not so well, but to require the purchaser to buy both rather than one singly could be abusive. Refusing to supply a company with products is another area where companies often are caught. Dominant companies should always make sure that they keep a detailed record of why a customer has been refused supplies. An existing customer which suddenly begins to undertake an activity which the supplier does not like, such as setting up in competition or selling products cheaply or selling them in a different territory, should not cut off supplies or be at risk of infringing Article 86. In the Hilti decision, the company Hilti refused to supply cartridges for a nail gun to customers whom it suspected would resell them to independent nail manufacturers. This was an abuse. In the UK, similar such actions can amount to anti-competitive practices, although there are few investigations each year. Consideration of scenario 2 in the case example could be given now. 3. Mergers. At EC level, large community mergers, as described above, will need to be notified to the European Commission in advance. This is an obligatory requirement, and notification must be made not more than 1 week after the conclusion of the agreement, or the announcement of a public bid, or the acquisition of a controlling interest. A significant amount of information has to be supplied to the European Commission, and the Commission has a fixed period in which to decide whether or not the merger is compatible with the common market, i.e. to be allowed or not. A decision has to be made within 1 month from the date of application as to whether or not to issue proceedings, and the final decision must be made not more than 4 months after the date on which proceedings had begun. If a merger has been implemented, then the Commission has powers to require that the company concerned be disposed of, and the Commission also has powers to examine books and records of companies. If a merger falls within the merger regulation, then it cannot be examined at national competition law level. This is different from the position under EC competition law generally. All agreements, for example, under Article 85 and in the UK, the Restrictive Trade Practices Act, have to comply with both sets of laws. Merger, or the market share of one of the parties extends over 25% for the first time, could be investigated by
Just pausing briefly to change the side. And it will resume in a few moments for the second side. The case studies are not now available, which are referred to on this tape.
falls within the merger regulation, then it cannot be examined at national competition law level. This is different from the position under EC competition law generally. All agreements, for example, under Article 85 and in the UK, the Restrictive Trade Practices Act, have to comply with both sets of laws. In the UK, mergers where the value of the assets exceeds £30 million or where the market share of one of the parties exceeds 25% and is increased by the merger, or the market share of one of the parties extends over 25% for the first time, could be investigated by the Monopolies and Mergers Commission. There is no obligation to notify a merger in advance in the UK, but the risk for a purchaser is that if they do not notify the Office of Fair Trading and obtain the OFT's views before the merger takes place as to whether or not it is likely to be referred to the Monopolies and Mergers Commission, they could be obliged to dispose of the company they have acquired after the acquisition. It is therefore common in sale and purchase agreements to state that clearance from the Office of Fair Trading is a condition for the transaction going ahead. For acquisitions where the deal is not secret, it is possible to make a formal pre-notification, but this ties the Office of Fair Trading down to a tight timetable, so it is not always recommended in practice. Many companies simply go to the Office of Fair Trading for confidential guidance as to whether or not the merger is likely to be referred. In either case, once the deal is public, there is a fee payable to the OFT. Even if the merger is not notified, in either way, a fee can be demanded, which ranges, depending on the value of the assets, between £5,000 and £15,000. The Office of Fair Trading has powers under Section 73 of the Fair Trading Act, where a merger is found to operate against the public interest, to make orders against the companies concerned. Schedule 8 sets out the orders which can be made, and these include making it unlawful to withhold supplies, and can require a disposal of assets acquired, such as a divestiture of the business acquired by the merger. In each case, one of the hardest questions to assess is what is the relevant market, and the Monopolies and Mergers Commission and the Office of Fair Trading look at what products are substitutable with the products concerned, in addition to a range of other economic tests and factors. The parties may well employ economists for large deals to assist in the presentation of evidence concerning the relevant market to the various competition authorities. Consideration could be given here to the third scenario in the case study. 4. Resale price maintenance. Companies should be free to resell their goods at prices which they choose. Many suppliers, for one reason or another, wish to maintain a high price for their products. Although in theory it should not matter to a supplier at what price a purchaser resells the goods, as the supplier has already made his profit, for some companies, particularly those which want to maintain a premium image for their brand, the maintenance of a high resale price is important. the law of both the EC and the UK is clear in that requiring a dealer to resell goods at a certain price is illegal. At EC level, price restrictions in agreements with dealers will infringe Article 85. There is a general or block exemption for exclusive distribution agreements, Regulation 1983-83, and this makes it clear that any restriction on the price at which the dealer can resell the goods infringes Article 85(1). The position is different with an agent. An agent who sells the goods of the supplier at a price and on conditions stipulated by the supplier, and effectively just arranges the sale between the original supplier and the customer, where the agent obtains a commission on the sale, can be told the price at which the goods are sold. This is because the agent is not selling the goods at all. He is simply arranging the sale between the supplier and the ultimate purchaser. The agent does not make any profit himself from the sale except his commission, and the agent is not legally selling the goods at all. The agent can be told the prices at which goods are sold. Not only could there be a breach of Article 85 where a company wishes to maintain a resale price, but also there might be an abuse of a dominant position where a supplier uses its strong market position to threaten a purchaser, maintaining that if the purchaser does not resell products at a price which the supplier prefers, then the supplier will cut off supplies altogether. In the UK, the Resale Prices Act 1976 prohibits minimum resale prices and provides that a condition in a contract with a dealer which stipulates that the dealer must not sell the products below a minimum price is unenforceable and void. The purchaser can be given a maximum price, although if there are any restrictions on the supplier in such a contract, then the agreement will need to be registered in advance with the Office of Fair Trading under the Restrictive Trade Practices Act 1976. The Resale Prices Act 1976 also makes it unlawful to withhold supplies from a dealer on the grounds that the dealer has sold the goods at a price below the resale price obtained. The resale price is defined as any price notified to the dealer or otherwise published. However, it is permitted to withhold supplies from a dealer who has been using the products as loss leaders. A loss leader is where goods are sold by a dealer, not for the purpose of making a profit on the sale of the goods, but in order to attract customers to the shop to buy other goods. A genuine clearance sale, though, is not regarded as a loss leader. Consideration could now be given to Scenario 4 from the case study. 5. Exclusive dealing. UK and EC competition law allows certain forms of exclusive distribution arrangements. An exclusive distribution arrangement arises where a supplier agrees not to sell products itself, or appoint other distributors for a particular geographical territory. Where there is a potential effect on trade between member states, then Article 85 will apply to the arrangement. Many companies have sought to divide the EC market on geographical grounds. Any attempt to give a dealer absolute territorial protection will infringe Article 85. Under the Exclusive Distribution Block Exemption Regulation 1983-83, all that a supplier can do is to give the dealer an exclusive territory, such as France or the UK, and state that the supplier will only supply those goods for resale to the dealer in that territory and to no other companies. The only territorial restriction which can be imposed on the distributor or dealer is that it should refrain outside the territory in relation to the contract goods from seeking customers, from establishing any branch, and from maintaining any distribution depot. An absolute ban on exports cannot be imposed. If such a ban is included, then there is a strong risk of proceedings being brought for breach of Article 85. And this is an area where the Commission has been quick to fine companies, often millions of écus. Companies seeking to prevent the parallel importation of their products throughout Europe have to be extremely careful not to infringe EC competition law. Once products have been put on the market in the EC by the manufacturer of the goods, or with the consent of the manufacturer, for example, by a licensee, then the manufacturer and owner of any intellectual property rights in the products cannot use their intellectual property rights to sue a parallel importer in connection with those goods which have been put on the market in that way, although counterfeit goods can always be stopped. In the UK, the Restrictive Trade Practices Act 1976, in Schedule 3, Paragraph 2, exempts an arrangement under which a supplier agrees only to supply the goods concerned, or goods of the same description, to one purchaser in a particular area, and the purchaser agrees to purchase those goods and goods of the same description only from the supplier. However, as soon as any additional restriction is included, the exemption cannot be used. In addition, the goods must be bought for resale, and this is the same under the EC distribution block exemption, and therefore various forms of remanufacture, or cases where the goods are being changed before resale, may not benefit from the exemption. In cases where the exemption does not apply, it is necessary to register the agreement in advance with the Office of Fair Trading. At EC level, where the block exemption regulation does not apply, an individual notification should be made to the European Commission for specific exemption of that agreement under Article 85(3). The Commission will then assess whether the agreement contains sufficient benefits to consumers that it should be allowed. And finally, compliance programmes. The European Commission imposes smaller fines in cases where companies have taken steps to ensure that their employees are aware of European competition law. This has been the case in a number of cases, most notably that of National Panasonic. Companies, therefore, are advised to undertake a three-stage process. First, there should be an assessment of whether their existing agreements and arrangements infringe EC competition law. The agreements should be examined and staff interviewed and working practices considered to find out the extent of any existing infringement. The second stage is to prepare a programme of education for employees, which can take the form of seminars and forms which they should sign, confirming that they have had the law explained to them. Different grades of employee may need different forms of explanation. Finally, the programme should be reviewed annually, and responsibility for the programme should be given to one individual to ensure that it is kept up. New employees should be informed of the obligation to comply with the law in this field. The programme itself will highlight those areas where companies are most likely to infringe competition law, for example, including non-competition restrictions in agreements, dividing markets or territories, networks of exclusive distribution and licensing arrangements, joint ventures, cooperation and research and development agreements which involve areas of specialisation, and more obvious price fixing and market sharing cartels. By operating a compliance programme, the company may be able to avoid liability in the UK for breach of restrictive practices court orders where a company is subject to such orders. This was the case in the Supply of Ready Mixed Concrete No. 2 decision, where the companies concerned had told their employees not to enter into restrictive arrangements, but the employees had nevertheless gone ahead and done so. The court held that the companies themselves had not been held to have been in contempt of court, as they had taken proper steps to prevent their employees from entering into such arrangements. It can thus be seen that such compliance programmes are very important and can lead to reductions in the huge fines which the European Commission is otherwise free to impose.
And that's the end.